All right, we're back. We're back in order. Clerk will read the caption to a group of privileged resolutions.
Honoring and commending Coach Brian Way on the grand occasion of his retirement. Recognizing and commending Representative Barbara Sims on the grand occasion of her retirement. Honoring Debbie and Les Schneider upon their 35th wedding anniversary. Honoring Elizabeth and Jeff McLendon upon the grand occasion of their 27th wedding anniversary. Recognizing and commending Dr. Shonda Moody Shaw. Recognizing the West Lady Wolverines basketball team, and for other purposes. That completes the reading of the privileged resolutions.
Is there objection to adopting the privileged resolutions? The chair hears none, and the resolutions are adopted. House will come to order. House will come to order. The clerk will read the caption to Senate Resolution 954, which was previously postponed to the next legislative day. Clerk will read.
Senate Resolution 954 by Senator Jeffries of the 17th, Jones of the 25th, Kennedy the 18th, and others, authorizing the grant of non-exclusive easements for the construction, operation, and maintenance of facilities, utilities, roads, and ingress and egress. This resolution had been referred to the Committee on State Properties. That committee recommends that this bill do pass, or that this resolution be adopted by committee substitute.
Chair recognizes Representative Donahue to present the resolution.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring to you SR 954, which is our annual easement legislation worked out by the State Properties Commission, the House Committee. We have one easement, and the resolution now carries 12 easements affecting 23 counties. Each year we do this, and this is for GDOT, Georgia Power, our EMC companies, where the 1.1 million acres that we lease or own in Georgia, we have easements that we give them the right to cross over to take care of our power needs or different things throughout the year. This bill is critical. However, we had one addition, the Sable Pipeline, and with that addition, they had applied in 2013 for the opportunity and permits to come forward with the pipeline. They were approved in February of this year after session, so that is the add-on. We have to remember that the easement that we come into with the Sable Pipeline is 1/4 of an acre. There's 5 crossing points, and with the 5 crossing points, they're under the river, and that's the only part of the 1/4 of acre that we're doing in easements. It has nothing to do with public land, private land, and that's basically what we're trying to do.
Do you yield for questions?
Yes, sir.
Chair recognizes Representative Buckner to your left for a question.
Does the gentleman yield?
Yes, ma'am.
Is it not true that the original version of this bill came from the Senate without the Sable easements on it?
Yes, ma'am. That is true.
Is it not further true that the easements that were added are all easements that are under rivers in our state?
The easement's a total of 1/4 of an acre.
But they're under the Chattahoochee River, they're under the Flint River, and they're under 3 other major streams.
Yes, ma'am.
Would you yield once more?
Yes, ma'am.
Is it also not true that this pipeline is going from Alabama to Florida and just passing through Georgia, and that there are no Georgia customers that will benefit from this pipeline?
Not necessarily. We have 4 stations that are tap-out stations, 1 pump station, 3 tap-out stations. And my understanding is Georgia has the opportunity, as the need fulfills later on, to add in, tap on, do whatever we need at the time, later down the road.
Does the gentleman yield for one last question?
Now, this is your last to your last. Yes, ma'am.
Okay, I appreciate your graciousness. Is it not true that over the course of the past year and a half, there have been literally thousands of people attending public hearings about this pipeline and raising their concerns, and there have been, in the majority of all of those meetings, there's never been people that were really overwhelmingly in support of the pipeline. They've been overwhelmingly opposed to this pipeline.
And to speak of, I'm sure you know of what you speak, I understand that 80% has followed through with this without any disruption. Out of the 20% that hadn't, I understand a small few has had a problem with it, but I wouldn't know the numbers to give you an actual account.
Thank you.
Thank you.
Do you further yield?
I'll take one more.
Chair recognizes Chairman Nix to your right for a question.
Yes, does the gentleman yield?
Yes, sir.
Is it not true I'm a little bit confused on this bill because I've got conflicting pieces of information on my desk? Is there anything in here that gives the eminent domain power to any private company?
Actually, the Congress has that right, okay? What happens, from my understanding of studying this further, let's say the pipeline tries to come down your property, they negotiate just like a road right with a GDOT. As they negotiate, you have the opportunity to make that decision for them to come through. If not, and negotiations are not reached, then that opportunity, they can take you to court just like GDOT can on a highway going by your house.
Does the gentleman further yield?
Yes, sir.
Out of all of the easements we're granting here, the part that affects the Sable pipeline is a very, very small part. Is that correct?
Yes, sir, 1/4 of an acre.
Okay, thank you very much.
Thank you.
Do you further yield?
No, sir. I think at this time I will step out and yield the
Even
well.
if it were a chairman?
I will take that question.
Chair recognizes Chairman Martin to your right for a question.
Gentlemen, I thank you for yielding. Gentleman yield?
Yes, sir.
I do want to make sure to follow up, if I can, on the gentleman's question. I understand that the federal government through FERC may give them the power for eminent domain in some cases. Is that not true? That's my understanding, correct?
From the definition I have, and was taken completely off, was FERC Commission does not have the power to grant eminent domain. Congress does have the right to do so if they want to.
But if the gentleman further yield.
Yes, sir.
That appears on other lands. The resolution we have before us does not, is it not true, that does not do anything with eminent domain? Is that not true?
That's true.
So just to be clear, what they can or can't do because of Congress and FERC, Congress giving FERC that, is one thing, is it not true? But the resolution we have before us today, is it not true that that is simply the conveyance that the state would give for their project and for others?
Basically, it is just for the 1/4 of a mile, 5 crossings on the river.
Well, and the other projects in the resolution, that
Right.
the other utilities. Is it not, last question, is it not true that at least one of those conveyances is important to get fuel to an electric generation plant down in southwest Georgia? It's critical.
I know that we're heading to Florida with it now, but we do have the future opportunity for Georgia.
No, to be clear to the gentleman, I'm not trying to confuse this. There's a conveyance in the bill now, in the resolution. There are a number of conveyances. Is that not true?
No. Just these 5. Brooks and Lyons, Colquitt County, Daltrey, Stewart, and those 4, excuse me.
That involve the Sable.
Right.
But there are other conveyances. Has the resolution changed since I?
No. The resolution has, as we started with each county. But Sable, we have these 4.
No, and to be clear, I'm trying to get back to the question. To be clear, there are conveyances other than the Sable Trail in there that are important to the rest of Georgia. That's what I was trying to get the gentleman.
As I stated earlier,
right.
With GDOT, Georgia Power, and our EMCs.
And it's not true that one of those is very important to deliver fuel to an electric generation station?
Yes.
Thank you.
Mr. Speaker, I'll yield the well.
The gentleman has yielded the well. We have other members that wish to be heard on the measure. The chair recognizes the chairman of the Transportation Committee, Chairman Coomer, to speak to the bill.
Thank you, Mr. Speaker. Interesting sometimes the things that we get spun up about down here and the things that we want to argue about, but this is one of them. This happens to be the one today. This bill, and to give you kind of a roadmap, I'm going to explain some of the basic legal sort of structures that we're dealing with, and I want to address the concerns that have been raised by some of the things that you've seen on your desks that have been handed out. And I'm going to tell you that the opponents of this bill have, from what I've seen, have 3 primary arguments. One is that this action isn't necessary because the state's not subject to federal eminent domain powers. That's not true. The second is that the action amounts to an act of eminent domain against private landowners by the state. That's not true. And the third is that this action will allow some sort of environmental catastrophe in Georgia, and that is not true. So let me explain kind of the legal background that gets us to where we are today and leads us to the decision that we have to take up now, and explain why we really should pass this resolution in the interest of Georgia's taxpayers. The legal basis for this action starts with a decision of the Federal Energy Regulatory Commission, or FERC. On February 2nd of this year, the United States of America, through FERC, issued a certificate of public convenience and necessity to Sable Trail Transmissions, LLC. And I have a copy of that for those who may doubt that. A copy of the FERC certificate right here. I'll show it to anybody who wants to see it. And the certificate is important because the holder of the certificate is granted certain rights under the law. And I've got some slides. If you could show slide 1. Title 15 of the United States Code, 15 U.S.C. Section 717F, the Natural Gas Act, or the NGA, provides that when any holder of a certificate of public convenience and necessity, that is the certificate I just told you about, when any holder of that certificate cannot acquire by contract or is unable to agree with the owner of property to the compensation to be paid for the necessary right-of-way, it may acquire the same by exercise of the right of eminent domain. The Court of Appeals for the 11th Circuit, which is right down the street here in Atlanta, has recognized that the NGA gives private gas companies the federal power of eminent domain to acquire the necessary right-of-way to construct, operate, and maintain a natural gas pipeline. That's in the case of Natural Gas Company versus Land, Coleman County, Alabama, 197 F. 3rd, 1368 at 1372. That's 11th Circuit case from 1999. In other words, Congress has given the FERC jurisdiction to determine if a proposed gas pipeline construction is in the public convenience and necessity. Once the FERC makes that determination and issues the certificate holder is authorized by Congress to acquire the necessary land. If necessary, the holder of the certificate may resort to the use of federal eminent domain. All that taken together means the certificate issued by FERC to Sable Trail Transmission on February 2nd gives Sable Trail the right to acquire property by use of eminent domain powers, regardless of what we do here today. Regardless of your vote, Sable Trail has that power granted by Congress through the Federal Energy Regulation Commission. The Congress has established, in this case, Sable Trail as its agent for exercising that eminent domain power. So this brings us to the first objection raised by opponents of the measure. They claim that the state is somehow not subject to federal eminent domain powers. They will say that the state of Georgia, as a sovereign power, is not subject to federal eminent domain powers and cannot be compelled to give up its property. However, that is an argument that's not based in the legal reality of our constitutional republic. The power to condemn, issued by the Congress through the FERC, is supreme to the power of the state of Georgia as a landowner. And that's been true since June 21st, 1788, when we ratified the Constitution of the United States. Article 6, paragraph 2 of the Constitution states, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land." That's called the Supremacy Clause. And this is not the first time the question of federal power of eminent domain has come up in the context of state property. You can imagine this is a concept that got tried pretty early on in our republic's history. Slide 2, all the way back in 1875, the United States Supreme Court ruled, "The federal government does not need the consent of a state or local subdivision to take its property for public use, so long as the federal government acts within its constitutional authority and pays just compensation. If the United States have the power, it must be complete in itself. It can neither be enlarged nor diminished by a state, nor can any state prescribe the manner in which it must be exercised. The consent of a state can never be a condition precedent to its enjoyment." Cole versus the U.S., 91 U.S. 371 at page 374, 1875. If you want more recent precedent, you can read Schneidenwind versus A&R Pipeline Company, 485 U.S. 293, that's a 1988 opinion, and Dominion Transmission Incorporated versus Summers, 723 F. 3rd, 238, page 243, a D.C. Circuit Court of Appeals opinion, 2013. In that case, the D.C. Circuit ruled that a state and local regulation is preempted by the NGA, the National Gas Act, to the extent they conflict with federal regulation or would delay the construction and operation of facilities approved by the Commission. So, what does all that mean? So thank you very much for asking the question. It means the state of Georgia can either agree to these easements, that would be a yes vote on your part today, or, and if you do so, you give an easement to the pipeline builders, which of course creates jobs for Georgians in southwest Georgia, one of the most severely impoverished regions of the state and country. Or you can refuse to grant the easements by voting no. And here's the rub. We'll be losers in a subsequent lawsuit. I mean, that's really what it comes down to. If we lose the suit, we may face an award of attorney's fees for the plaintiffs because we don't have a good faith basis to refuse this condemnation process. So if you want to go ahead and deduct next year's appropriations by about $1 million, then vote no, because that is what you're effectively doing. There's no legitimate legal defense to that position, and the court is going to award attorney's fees against the taxpayers of this state, courtesy of those who vote no on this bill. Now look, I want to be clear. You haven't heard me call names or raise my voice or get upset or be ugly in any way up here, because this is just not that kind of issue. You haven't heard me raise all kinds of scary scenarios about what's going to happen. I've told you one thing that's going to happen, and that's a fact. If you defeat the bill, you will pay for it in next year's budget, period. End of story. So, let me get to the eminent domain against private landowners. SR 954 grants easements on state-owned property and does not grant eminent domain powers over private or public lands at all. Eminent domain only comes in when a public actor and a private property owner cannot agree to a price, and in this case, in the case of Sable, this is not an area for concern. Next slide. And I think you'll find this interesting. Oh, you can't see the top of my slide, unfortunately, but what this slide shows is the total number of tracts to be acquired in Georgia that have already been acquired, and those that have already been acquired and will be acquired. The total number of tracts involved in Georgia are 582 tracts, 526 of which have already been acquired. So 90.38% of the tracts involved have already been acquired. Next slide, slide 4, shows the number of landowners involved, and it shows that 450 total landowners are involved, and 408 landowners have already given permission for these pipelines to cross their land. The reason I point that out is because it is not the case that there is some overwhelming groundswell of opposition to this back home or back in the districts that are affected, because over 90% of the folks involved have already agreed. They've already consented. They've already worked out a deal with Sable. So they're not getting railroaded at any means. We're just the next participant in the process. Next slide. The next slide is very important because it says what the public policy of the state of Georgia is today with regard to natural gas pipelines. And it says, OCGA section 22-3-88 says, the power of eminent domain may be exercised by persons who are or may be engaged in constructing or operating pipelines for the transportation or distribution of natural or artificial gas. Now, why do I have this up here if we're not talking about state eminent domain? Because I want to make clear, we've already decided the policy of this state is such that if a natural gas pipeline construction wants to go forward, they can exercise state eminent domain powers to do that. If you want to change that policy, the proper way to change that policy is through a bill changing that law. It's not a vote no on this bill. A vote no on this bill just costs the taxpayers lots of money in attorney's fees. So it's already the policy of the state. Now let me get to the environmental piece, because the legal arguments and policy arguments against this bill relating to or arising from the concept of eminent domain are really without merit, entirely without merit. So once you overcome those arguments, you're left with only one remaining issue, and that is the sort of environmentalist fear-mongering that goes on. We saw this tactic in recent years over other pieces of legislation. For example, when we had the Flint River bill. Y'all remember the Flint River bill? Remember when those folks who are out in the hall who are very interested in environmental concerns came to you telling you how important it was that we protect private property interests? People who don't care about private property interests coming to tell you how much they care about private property interests. It's the same thing here. This is an issue of environmental concern that the environmentalists have ginned up to say that they're going to vote against this because it has to do with private property rights. That's not true. It was a non sequitur on the Flint River bill. It's a non sequitur today. We know most really avid environmentalists will run roughshod over private property rights in the pursuit of an environmentalist agenda, and that's what's happening here. Now, if you are just opposed to this action because of your pure environmentalist bent of mind, then say so and vote so. That's honest. That's what we're here to do. But to the rest of the members, I would charge you, don't be deceived and don't make a mockery of the process that we have here. Vote yes to follow the law and to do what we're supposed to do. I encourage everyone to vote yes for this measure, regardless of your political preference, because, among other things, voting no is a statement that you'd rather pay $1 million to trial lawyers, I have no problem with personally, than to be responsible stewards of the state's physical resources, and I do have a problem with that. So please vote yes. A lot of us like to run and talk about running the government as a business, and if we were in a business, this is what I would say. If we were in a boardroom right now, this is what I'd tell you. I'd advise you that if you fail to take this action, we'll be sued and lose. And we will probably be ordered to pay attorney's fees, a lot of attorney's fees. And I'd tell you that your failure to act will result in a loss that the shareholders won't approve or appreciate because we would be wasting the company resources. I ask you not to waste the state's resources. Vote yes on this bill and move along. Thank you. Actually, I'll stand for questions, Speaker.
Well, you have a few.
I can't imagine why.
Chair recognizes the chair of the Natural Resources and Environment Committee, Chairman Smith, for a question to your right.
Thank you. Gentleman yield.
Of course.
During this process of approving Sable in the state of Georgia to run this pipeline, is it not true that the DNR board actually took an action? And is it further not true that the pathway under our rivers is so many feet below? Could you speak to how many feet below the riverbed it is?
What I can tell you, thank you for the question. What I can tell you is this process, which is a federally regulated process, necessarily involves oversight from the Environmental Protection Agency. If anyone is concerned that the Environmental Protection Agency is not strict enough in its regulation of environmental concerns, I'm not sure what newspapers have been reading or publications they've been subscribing to, because I'm well convinced that the EPA has the ability to strictly monitor this process in a way that does not harm our rivers and streams. And and to the lady's question, there is a substantial depth. I want to say it was 60 feet below the bed of the rivers is what the depth of those pipes will be.
Thank you.
Thank you.
Do you further yield?
Yes, sir.
Chair recognizes Chairman Houston to your right for a question.
Thank you. When this bill left the House, this Sable Trail wasn't on. Why did y'all put it on later?
Well, I didn't put it on. It came in the committee. And my understanding is the reason it's on there is because we are going to we have to either put it on voluntarily or we have to face a lawsuit and have it done to us by the courts.
Why was it put on when it went through the committee process here in the House?
I think it did get put on in the committee here in the House when it came back.
Before we sent it to the Senate, it was not on, I don't think.
I believe it got put on in the House committee when it came back.
Not before.
Yes, ma'am. Right. And all I can say about that is the timing may have been the issue. The certificate was issued on February 2nd. I don't know when we passed the original state properties bill out of this chamber, but my guess is it probably had to do with the timing of the federal government's action on February 2nd.
Can the federal government require us to put it under the rivers, or we have to give the federal government permission?
The federal government has the power of eminent domain, and they can enforce that eminent domain power against the state of Georgia. So the federal government can force us to give an easement to that state-owned property.
So why are we voting on it then if the federal government can tell us what to do?
Because if we don't take it up, then the other side has an argument that we've acted in bad faith in refusing to do this, and then that's when they get an award of attorney's fees. If we act in good faith and cooperate and do what the law requires us to do, we're not going to lose attorney's fees in the process. If we don't act, that's when we have to write a check for attorney's fees because we've acted in bad faith. But arguably. I'll say for the record, I think we're all acting in good faith, and I hope we don't pay attorney's fees regardless of the outcome of this vote, but that's what's going to happen.
All right, thank you.
You got a bunch of questions. Do you further yield?
I'll yield. Yes, sir.
Chair recognizes Representative Trammell to your left for a question.
Does the gentleman yield?
Yes.
Can you speak to the size of this pipeline?
The pipeline is 36 inches. About that wide.
Do you further yield?
I'll yield for one more, Mr. Speaker.
Chair recognizes Representative Oliver to your left for a question.
Does the gentleman yield?
Yes, ma'am.
I'm interested in your argument about attorney fees. Isn't it true, sir, that many very, very smart lawyers believe that the state will be sued, assuming the governor signs the RFRA bill, 757? And isn't it true that upon that lawsuit, attorney fees will be paid by the state of Georgia? Is that not true, sir?
I do not think your statement is correct.
There's a fair legal dispute about the court will order attorney fees to be paid, but it's certainly true in the view of many lawyers that attorney fees will be paid by the taxpayers to litigants on RFRA. Is that a fair statement?
Again, I'm not following your logic, and I don't think that's correct. What I would say is that it is very clear and well-settled law since the beginning of this republic that the federal government has a power of eminent domain over the states as property holders, and we don't have an excuse for not obeying the law in that regard.
Further yield, sir.
Last one.
Last one.
Yes, ma'am.
Isn't it true, sir, that the taxpayers are paying attorney fees in many different cases, and I could name 5 for you right now, based on bills we have passed, and that is not an argument to vote for or against a bill, because we do have fair-minded legal arguments to make as to who is right or wrong, and your assertion that attorney fees will be paid is countered by others. Isn't that true, sir?
Well, I'm sure everybody can make an argument that they wish, but I would point out that this is not a substantive bill that we are taking up a new policy of the state. This is the question of our obligation as landowners, and this body as the stewards of the property of this state, and whether or not we have to follow the law as it's been established by the Constitution and the Congress. The answer to that question is yes, we have to do it, and that's why the members should vote yes on this resolution. Thank you.
Gentleman has yielded the well. Chair recognizes Representative Stover to speak to the bill.
Thank you, Mr. Speaker. Attorney fees, $1 million. $1 million attorney fees. Attorney fees, $1 million. If you say it enough times, it becomes true, right? That's all I heard during the entire argument. Attorney's fees and $1 million. It's got to be true now, no doubt. This pipeline is 36 inches round. The average natural gas pipeline is 12 inches. If this thing is 65 feet below a river and it blows, if it's 65 feet below a river and it blows, what happens to the river? Where does the river go? There's something called the Floridian Aquifer that runs through this area as well. So we're going to inject our groundwater into the Floridian Aquifer through a blow? That sounds like a great idea. There's another reason this bill is so important. Governor Rick Scott has an investment in the Sable Pipeline. The same governor we fought over water, the same governor we sued back and forth with over water. The governors of Alabama have sued us over water. But that lawsuit's okay. This pipeline has no business going through Georgia. It's an Alabama to Florida connector. Run it down the Alabama line. Keep it in their state. The only reason there are 4 taps on this pipeline is so we could argue eminent domain was okay. That's the only reason they're here. Go back to the original proposal for this pipeline. There were no taps, not a single one, not a single damn one. We're putting this to the poorest part of our state in some of the most populated area. If this pipeline was going to be stuck in the middle of Alpharetta, would we be having this argument right now? If we had a vending station in the middle of Alpharetta, would we argue this bill? 12 to 14 times per year, methane gas will be vented into these neighborhoods. You can't tell me that's a good thing. Mr. Speaker, with that, I yield any questions. If there are none, I yield the well.
You have a question if you care to yield.
I do.
Chair recognizes Representative Kidd to your left for a question.
Thank you, Mr. Speaker. Gentleman, yield.
I do.
In your opinion, of course, I'm in the loan business myself, and I do business with Wells Fargo. In your opinion, when the pipeline goes through your property or someone's property, does it not devalue that property? And some lenders, like Wells Fargo, in the letter we have from Wells Fargo, says it devalues your property and they will no longer lend you money on your property.
I believe the gentleman knows of what he speaks.
You have another question?
I do.
If the scenario that this bill is voted down as is, it gives us the opportunity to ask for reconsideration, then take the bad part off and pass the original bill. Is that not true?
That is absolutely correct, and that's the way that it was passed the first 2 times.
Thank you, and that's what I urge people to do. Thank you, sir.
Thank you, Mr. Speaker. I yield the well.
Gentleman has yielded the well. Chair recognizes Representative Dukes to speak to the bill.
Thank you, Mr. Speaker, and thank you all for giving me an opportunity to speak to this measure. We are very concerned in Albany and Dougherty County about the pipeline. We're concerned about it for a number of reasons, and the biggest reason is that the adverse impact that it will have on the state of Georgia. You see, when you go through Southwest Georgia, what you're coming through is a little place we call God's country. It is some of the most pristine agricultural area of the state. Agriculture in the state of Georgia is worth $14.1 billion a year. The most of your peanuts and your vegetables is grown there more so than any other region. To have a pipeline that erupts or bursts in that area will be damaging to the aquifer in our part of the state. And it's not as if it's something that is totally out of question. The route of the pipeline goes across, we can identify 70 potential sinkholes. And yes, it's a huge pipeline. It is 36 inches. The largest pipeline going through Dougherty County now is a 12-inch pipeline. That's what we have. It goes through our water wells. Better than 40 sinkholes have been identified where it goes through there. The water wells in our community provides drinking water for approximately 30,000 of our residents. Now, I spoke to you about the adverse impact that it has on our agriculture community. And it has been stated, I mean, the agriculture commissioner, when it came down to where the pipeline was going through a particular area, he said that he understands that Florida desires and needs the energy, but we respectfully request, and I respectfully request, that they take an alternative route to accomplish this objective. Now, it is not unheard of for Sable or the apparent company Spectrum to have these kinds of interruptions. From 2006 to 2013, they have had a total of 21 incidents here, costing property owners over $8.5 million in value. Not only that, last year, they had a pipeline that went under the Arkansas River, and the pipeline erupted and shot out water out of the river as if it was a geyser. The pipe, Sable, nor Spectrum had even realized that this intrusion had occurred. It was a guy who owned a barge, couldn't get down the river, notified the company that there was an infraction. In Louisiana last year, the compression station that they had there blew up, killing 3 people. And that is one of the biggest things that the people in Dougherty County and the city of Albany has the greatest objection to. You see, it is a 500-mile pipeline. It goes from Alabama to South Florida. There is no rhyme or reason as to where you place a compression station. They first decided that they were going to put a compression station in Dougherty County. 100,000 people. The only other place they put a compression station, the highest population of people, was 16,000 people. Well, I'm sorry, 10,000 people. It ran from 1,600 to 10,000. The people of Dougherty County protested, and they came back and decided they were going to move the compression station from the county of Dougherty and placed it in the city limits. In the city limits. 3/10 of a mile from 50 homes and within a mile of 500 households. Now, this is what a compression station does. Or this is what this one will do. It is 6 stories high. It will be the tallest thing in Dougherty County. It puts out over 1 million cubic feet of methane gas every year. Now, this is particularly concerning to us because we already have over 279 attributors to adverse attributors to air quality in our community. Southwest Georgia has the highest propensity of cancer than any other region in the state. They decided to put it within the city. I'm not against economic development. In my community, I served as the Economic Development Commissioner for 9 years. But this is not economic development for Georgia. You see, the gas goes from Alabama to Florida. Better than 93% of the gas is already pre-sold to Florida Power and Light and Duke Energy. The only reason they put a tap in anyway was so that they could be able to get eminent domain. We sued. People of Dougherty County, Albany sued the landowners. They decided they were going to add a tap. This is a real issue for the people of our community and the people of Southwest Georgia. We call upon you, and I call upon my colleagues, to support not only the people of Albany and Dougherty County, but the people of Georgia in denying Sable Pipeline the opportunity to go on our rivers. Mr. Speaker, I yield the well.
Chair recognizes Representative Quick to speak to the bill. Just a minute, Representative. This House will be in order. Please give members in the well your attention. Lady may proceed.
Thank you, Mr. Speaker. Colleagues, I rise this afternoon in opposition to SR 954. And there are several reasons for that opposition. And when Chairman Coomer came to me last week to ask me about my opposition to this measure, I told him those three concerns that he outlined. And I want to go through them with you here this afternoon so that you can understand what you're voting on, which I think is the most important thing that we can do for our constituents, is to understand what we're voting on. So in looking at the bill, if you take a look beginning at section 131, starting at lines 895, these are the Sable, what we're calling the Sable easements. And if you'll just put this map up that we've got here, it will show the counties that we're talking about that comprise the Sable easements. Now, my concerns are really threefold, and one of them is with regard to our agribusiness and agriculture industry in Georgia. And it does relate to the Floridian aquifer because, as we know, the aquifer is that gift from whom all blessings flow in Southwest Georgia, in terms of why we are the breadbasket for not just Georgia, but in many respects the world in terms of our farmers. The second objection that I do have is because from a public policy standpoint, we do not do eminent domain for anything other than a public purpose. And to the point that was raised over here about that this is not about eminent domain, it absolutely is about eminent domain, and here's why. Because we are the last link in the chain. We are the last link in the chain for the FERC process. When we grant this easement, we permit, by yes vote, you will allow a private company to then exercise eminent domain over citizens of this state along this pipeline route and through these wildlife areas and these areas of our natural resources in Georgia. And so make no mistake that that is what a yes vote will permit in terms of this situation. So we don't do that unless there's a public purpose for Georgia in this state, a public purpose for Georgia citizens. And I'll get back to that in just a moment. But that goes and sort of segues into my other policy objection to this, which is on a state sovereignty point. And I'll just say, you know, we talk a lot here in this body about standing up to the federal government. We pass urging resolutions about standing up to the federal government, and we rail against the federal government. Well, guess what? I've got great news for everybody who has railed against the federal government in the 2016 legislative session. Here is your chance to push your button and put your money where your rhetoric has been for this session. Because by voting no, you will tell the federal government, take your FERC process and take it down to the Panhandle and across Apalachicola Bay and not through the Flint River area of Southwest Georgia when this does not serve our citizens. Now, don't take my word for it. I've been putting stuff out on your desk for several days because this keeps coming up and getting postponed and coming up and getting postponed. So I'm sorry about that. Y'all are probably tired of seeing things from me on your desk. But indulge me and take a look at the one I put on your desk today. And it is directly, you know, we do this in court sometimes when we take other folks' words and turn it around and say, these are your words, not my words. And so take a look at the Sable Pipeline website. And I've started for you so you don't have to look too hard for it. Once completed, the Sable Trail Pipeline will deliver domestic natural gas supplies to Florida Power and Light and Duke Energy Florida for their electric generation needs. For their electric generation needs. And as Representative Dukes alluded to, by contract already, you can get on your smartphone, if you're bored listening to me, you can get on your smartphone, get on your iPad, and take a look at the Sable website and link to some of these FERC documents and see the contracts that specify that 94%, approximately 94% of this capacity for this pipeline is pre-committed to Florida. And so why are we putting our natural resources for the sovereign state of Georgia at risk to benefit Florida? I don't know. I don't know. I cannot think of a good reason to do that. And I will not be complicit in it for the federal government or anybody else in terms of this scheme. If you'll put the next map up there, I started wondering about the Flint River. You know, I opposed that measure until it was changed and got right for private property rights for over about 2 sessions down here. And I'm going to oppose this measure until we hopefully send it back to rules and strip out these Sable easements and get it right for private property rights. Because that's the right thing to do, because here's the Flint River crossing, and so this is the part of the Flint that they are proposing to cross. Now there are other waterways that are implicated, as was outlined previously. Okay, there are others. And I have drawings and maps back at my desk if you want to see the way the crossings are on the Chattahoochee, the other rivers, and the creeks that it crosses. But so what does that mean exactly? If you'll put up the next slide, they've drawn some to show how it's going to go under the Flint River and into the aquifer. And so on Wednesday, I had put on your desk, actually Representative Buckner had on your desk something from a hydrologist that indicated that this area down here does go through and into the aquifer in terms of where this around the Flint is going to go through. So what really is going on here? And just as a practical matter, if it was so important, why are we dealing with it in the way that we're dealing with it? And by that I mean, to the point Chair Lady Houston made, it came over from the Senate without these easements in it. And it came up differently in the process. And I want to touch on that just a minute too. It came up in the House committee that these easements were put on here. This is not the way it came through the Senate. And so when something comes out of left field, I've only been here, this is my 4th session, but when something comes out of left field like this, in my mind, that means I am on heightened alert. I am on heightened alert to scrutinize and try to research what is really going on here. And so for me, when I started looking at what was happening here, it was elementary, sort of like ABC. And I'll just go through what I thought about this. A is for the aquifer, okay? And I have touched on that in terms of these maps for you, that the Floridian aquifer, to be precise, and we know how important that is to our agriculture industry. industry. B is Breaking Bad. Okay, and that's what this thing did out of the House State Properties Committee, all of a sudden out of left field when it was not in the Senate easement process. You know, Representative Donahue has done a fabulous job of dealing with this situation that is has been thrust on him. And I just want to say to my friend, thank you very much for the manner in which you have handled this in terms of the position that we've all been put in, as this has been different than our state properties process typically is. Because usually, you know, the folks who represent these areas get an opportunity to object to these things. And in fact, the senators who represent this area down there were successful in saying, we object to this, and we don't want this in the bill that's starting with the Senate. And so one of these things that you're voting on, in this bill at least, is not like the other, and it is the Sable easements. They are not like the other. So that gets me to ABC. So what is really going on here? Well, maybe the Chamber of Commerce. C is for Chamber of Commerce, who has put a letter on your desk, the same letter for 4 days in a row, telling you that this is not about eminent domain, not until you vote yes. And then it's going to be about eminent domain, so I guess their statement is maybe half true, a bit misleading to you, but half true. It's not about eminent domain until you vote yes. And so C is for Chamber of Commerce, C is for crony capitalists, the Sable company who will benefit from this, and the power of eminent domain that you give to them, and now Chicken Little. The sky is falling. The federal government's going to sue us. So let's legislate like Chicken Little. Nobody sent me here to legislate like Chicken Little. And so when Chairman Coomer came to me and asked me what my objection was to the bill, and I told him just what I've told you, in perhaps not with quite the flowery flourishes in some areas, and told him that if he would bring me a case, any case that was an eminent domain case where the state of Georgia or another sovereign state was a landowner and the federal government exercised eminent domain directly against a sovereign state of this union, I would stand down. And I would not come to the well. I would stand down. And the first time I've seen this citation is on the screen today, and it didn't have a state's name in it. It wasn't a state versus the United States of America. So I'm going to stand by until somebody shows me a case whereby the United States of America can condemn by eminent domain the property of the state of Georgia, the sovereign state of Georgia. I'm going to stand by my position on this, because otherwise they could come take us over tomorrow, and I don't think that's the law. I'm going to stand on that till I get a case. So perhaps there'll be one, but Cole versus U.S. was not a state versus the United States. Long ago, once upon a time, in a land far away, it seems sometimes, the Republicans took the majority in this state and in this House. And I've been coming down here in some capacity since that time, and one of those proudest moments for me was in response to the Kelo versus City of New London case, the U.S. Supreme Court in 2005, when this body passed the Landowners' Bill of Rights and Private Property Protection Act. And it protected citizens against eminent domain for situations which were not for the public good and the public use. And ladies and gentlemen, I would ask that you join me in standing up and saying this process needs to work differently, that we do not agree to grant an easement to Sable, whoever they may be, for $650, which is what's in the bill, $650. So, Mr. Speaker, I will be happy to yield for questions if there are any, and if not, be happy to sit down and listen to what my colleagues have to say.
You have a few questions if you care to yield.
Yes, sir, I yield.
Chair recognizes Chairman Coomer to your right for a question.
Gentlelady yield.
Yes, sir.
Thank you. You talked a little bit about the citations to authority, and I wanted to ask you if you have any citation to authority for your proposition that the states are not subject to federal eminent domain powers.
Just the U.S. Constitution, that we are a sovereign just like the United States of America. That would be my citation, Mr. Chairman.
So you cite to the Constitution of the United States. Do
Yes.
you also prescribe to Article 6, Paragraph 2, that says the Constitution and laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land?
Yes, sir.
And so do you then disregard that when you argue that that part of the Constitution doesn't apply here?
Mr. Chairman, I would say that that's amplified by the 10th Amendment and the sovereignty of our great state. And I look forward to being able to research that case and get back with you on that you put on the board.
Okay. So as I understand it, then you have no authority whatsoever to come against the authority I cited when I was in the well.
I would dispute that authority is on point, Mr. Chairman, given that it was not a state versus the United States in this situation, because we are no ordinary landowner in this situation.
Well, you're aware of the practice, if the gentlelady will yield, are you aware of the practice of having a state official named as a party when a state is sued?
Yes, sir.
Would it surprise you to learn that Mr. Cole was in fact the representative of the state of Ohio in Cole versus the United States?
Could very well be, Mr. Chairman. I'll have to look at your case.
All
I
right.
would have liked to have looked at it before today.
And last question, you said in your argument that we will allow private companies to exercise eminent domain if we vote yes. And you said that after taking some time to look through the bill, and I would ask you, where in the bill, or where anywhere, can you show that a vote to allow an easement on state property is a vote to allow a private company to exercise eminent domain?
Mr. Chairman, that's because a vote to grant this easement will allow Sable to cross the Chattahoochee and bring this pipeline into Georgia. If we don't allow it, they can't come in.
Thank you. No further questions.
Do you further yield?
I do.
Chair recognizes Representative Johnny Caldwell to your left for a question.
Does the lady yield?
I do, Judge.
Isn't it true that the other easements that are in this bill are to Georgia Power, MEAG, EMC, and all of those entities are controlled by the Georgia Public Service Commission?
That is correct, and the gentleman knows of what he speaks.
And isn't it also true that because of that, they can regulate and have control over those entities, and we get a direct benefit from those entities, like all of the other pieces of this legislation, because they may be going to the technical colleges or some other college or to some entity in a city or a county. But this private company doesn't do anything for the state of Georgia, and it's only going to pay $650 for a right-of-way to go under our rivers that could explode and also then inundate the Florida aquifer.
That is true, sir. It's not a particularly good deal. If the lawyers have been negotiating this deal, it's a particularly bad one for the citizens of Georgia. Somebody needs a better lawyer.
Do you further yield?
Yes, sir.
Chair recognizes Representative Al Williams to your left for a question.
Will the gentle lady yield?
Yes, sir.
is it not true that there's an old African proverb that says, when elephants fight, grass gets trampled?
I'm sure the gentleman knows of what he speaks.
I've been trampled a while, and I've enjoyed this. But I'd like to call the question. I've admired you. If it was in keeping with the rules of the House, I would raise a hymn, and Reverend Jackson here would take a collection. We have enjoyed it.
Thank you, sir. That's high praise coming from you. Thank you very much.
Do you further yield?
Yes, sir, Mr. Speaker.
Chair recognizes Representative LaRicchia to your right for a question.
Gentlelady yield.
Yes, sir.
Is it not true that some of us get dizzy when we listen to you lawyers and maybe a judge here and there go back and forth, but is it not also true that perhaps the reason there are no cases where the United States has taken on individual states or sovereign states is because, like me, we believe to have good neighbors, you got to be a good neighbor, and that they may have worked something out like we're trying to do and voted to pass it and didn't have to be challenged.
I'm not sure if that would be true or not. The federal government hasn't been a very good neighbor to the state of Georgia. It's been my experience.
You have more questions.
Yes, sir. I'll yield.
Chair recognizes Chairman Setzler to your right for a question.
To the lady of the will, do you yield?
I do, sir.
I stand here still undecided on this proposition. I started that way, and I have not been convinced either way. I do have a couple honest questions that I just legitimately don't know the answer to. If the federal government were to use condemnation power or eminent domain power to take land, do you know if they would have a narrower mandate, or would their ability to use the land be more narrowly construed because they'd have to demonstrate in court the use of the land in the most narrow way? And does this bill, if we should pass this resolution, would it grant a broader use of the land? And could you speak to that issue at all if we're trying to understand in practice the difference between the federal government taking the land or us granting it through this resolution?
I'll try, Mr. Chairman. I can't find any direct authority to allow the United States of America to take land owned by the state of Georgia, but I will say that if these easements are granted under the waterways in this fashion, then the FERC process will grant Sable, the private company, the right of eminent domain. So that is the result of the grant of the easements.
I mean, I asked the question because I was persuaded by Chairman Coomer's presentation that the federal government through FERC does have the power to take this land, but only in a narrow way to bring about to make the pipeline happen. I'm just trying to understand what the effect in practice would be on the environment or some of the things you bring into question, the Floridian aquifer. Is the outcome going to be different if we pass this resolution or if it's taken through condemnation? Because I do believe they have the power to do that. I'm trying to understand if there's going to be a difference in practice of those two circumstances.
Well, I think one of the situations that would arise if we do not grant these easements is we actually give our lawyers something to negotiate with to do precisely what was mentioned here, to negotiate with the federal government if they're going to try to exercise eminent domain, or to negotiate with Sable if they are thinking they're going to try to exercise eminent domain against the sovereign state of Georgia.
Does the lady further yield?
Yes, sir.
Could you draw the distinction for me? I'm still trying to understand the change that's happened since this bill came over, or this resolution came over from the Senate, these Sable easements. Could you draw very clearly for us the distinction between those easements and the other ones that have been referred to? I'm still a little unclear on that.
Yes, sir, Mr. Chairman. These easements were not contained in the bill that passed the Senate.
I understand that, but what's the nature of them? If those easements weren't in this resolution, what would be in the resolution?
What would be in the resolution are the easements associated with all of our Georgia providers that are intrastate within the state of Georgia, not interstate serving Alabama and Florida pipelines. So what would remain in the easement are only those regulatory authorities that we have control over.
Okay, so if this body were to restore that proposition, then those interests could move forward without the Sable piece being a part of that. Is that correct?
That is correct, Mr. Chairman.
One last question, if you'd
Yes.
yield. The 94% gas being committed outside of the state of Georgia, could you substantiate that a little bit more? One of the advantages that I understood this to bring is we could tap into this pipeline and use it as a meaningful tool for economic development in southwest Georgia. Is that true, or are we truly limited for the life of the pipeline only to 6% of the use?
Yes, Mr. Chairman, I've got the order issuing certificates and approving abandonment here, and also all the FERC filings at my desk, and I'm gonna yield the well here. I know everyone will be grateful. I'm gonna yield the well here and come bring that to you. So I will be right over with that. With that, Mr. Speaker, I'm happy to answer any questions on the floor for members, but I yield the well and ask for a no vote on SR 954.
Lady has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. There is a minority report. She waives.
Mr. Speaker, I'd like to be recognized to make a motion.
The chair, you should have discussed that earlier with the chair. You want to come up here and have that discussion?
I will do that.
The lady has waived the minority report. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill or the resolution? The chair hears none. The report of the committee is agreed to. Shall this resolution now be adopted? All those in favor of the adoption of Senate Resolution 954 will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the adoption of Senate Resolution 954. The ayes are 34, the nays are 128. The resolution has failed. For what purpose does Chairman Coomer rise?
Serve notice of intent to ask for reconsideration.
The chairman has that right, and the time to do that is now. Now, the posture is this. The gentleman has moved that this House will reconsider its action. This is a procedural vote. He has the right to do that. We're going to vote right now. This is for reconsideration only. All of those in favor of reconsideration will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the Motion for reconsideration. The ayes are 146, the nays are 17. This House has reconsidered its action. The bill goes back to the calendar to be voted again, except for what purpose does Chairman Coomer rise?
Make a motion.
State your motion.
Move to recommit Senate Resolution 954 to the Committee on Rules.
Gentleman has that right. The gentleman has moved that Senate Resolution 954 be recommitted to the Rules Committee. Is there objection? Chair hears none. It's on its way back to the Rules Committee. Okay, let me tell you the posture that we're in now. The conference committee report on the FY17 budget has been on the desk, I'm told, since 1:40 p.m. Chairman of the Appropriations Committee had asked that I announce that Martha Wigden and Christine Murdoch from the Budget Office are in the anteroom and are happy for you to come in and visit and ask questions on the budget, and you're going to have some time to do that. I want you to take advantage of that opportunity. If you have questions on the conference committee report on the budget, we will be taking that up later, but the chair did want you to have as much time as is possible to review that. Chair recognizes the chairman of the House Rules Committee for an announcement.
Thank you, Mr. Speaker. Ladies and gentlemen, there will be a Rules Committee meeting at 4 o'clock, 341, 4 o'clock.
The House will be in recess until 4:15.